All right, good afternoon. My name is Ryan Stevens with the Griffin and Stevens Law Firm in Flagstaff over on Humphrey Street, just a few blocks from the courthouse. And today we're presenting on this topic of arrested for DUI, what happens now? So we'll just jump right in. The plan will be to go over some basic definitions first. The definitions are really necessary contextually to understand the process, and what we're kind of talking about is the process of how a DUI case kind of starts, when the arrest occurs, and then what happens from there. But the definitions of DUI and some of the topics associated with DUI will be very important to understanding why the process is what it is, and just understanding in general what to expect. So after the definitions, we'll talk about the process and procedure of a case and how it works in the court. So in terms of definitions, there are many different types of DUI under Arizona law. There's a separate type under federal law that we'll just kind of touch on today, but most of what we'll talk about is Arizona law. But there is something that is consistent in every single DUI statute, every single definition of DUI under Arizona law, and that is the government would have to prove, the state would have to prove that a person was driving or in actual physical control of a vehicle. And then we'll talk about the distinctions in DUI law from that point forward. But first, every single DUI must either have proof of driving or actual physical control. Driving is a fairly simple definition, operating a motor vehicle and moving it. Actual physical control is a little bit different, so we'll touch on that briefly. For example, a question that comes up in some cases is, I got charged with DUI, but how can that be? I was parked legally in a legal parking space. So how do I have a DUI charge? Can I get a DUI? The answer is yes, it is possible, even if the vehicle's not moving, even if it's parked. There are several factors. We're not going to go through in extreme detail as to what those are, but for actual physical control, it is possible to be in actual physical control with the vehicle in park. All right. So actual physical control, what is it? We often refer to it as APC. So if you see APC in this presentation, it's in reference to that topic of actual physical control of a vehicle. So what is it? There is one easy answer, and that is it's basically up to the jury. So if you're not driving, but you're accused of actual physical control, DUI, you can go to trial, and a jury will have to decide, is the evidence sufficient to prove that you were in actual physical control or not? There are a number of factors under a case called Zaragoza that the judge would educate the jury. So the judge would give this legal guidance to the jury about what are the factors that they should at least consider in determining whether somebody's in actual physical control of a vehicle. But at the end, essentially, it just says whatever else the jurors think is important, they may consider. So it's really up to the jury ultimately. Beyond the topics of just driving or actual physical control, there are several types of DUI offenses under Arizona law, so let's go through those. First, the most basic, lowest level, simplest DUI under Arizona law, most people would suggest is the .08 law. Most people know that to be the legal limit, so to speak, .08 DUI, or a blood alcohol concentration of .08. But there's actually one that's even more simplistic than that, and that is if you're impaired to the slightest degree by alcohol, drugs, or vapor-releasing substances, which we won't talk a whole lot about. But basically, if you're impaired to the slightest degree by any of those things, or the law says a combination of those things. So if somebody smokes marijuana and has THC in their system, they can be a DUI alone, just with that. Or if there's alcohol and THC combined, and there's proof of impairment to the slightest degree, that would work as well. Impairment to the slightest degree is what it sounds like. It means that the jury would be convinced, if you went to trial, that that person was impaired at least a little bit, at least to the slightest degree, and was driving or in actual physical control of a motor vehicle. All right, so that's the most simplistic one. One thing about that you might notice is it doesn't have a BAC, a blood alcohol concentration. So there is no .08, there is no scientific evidence associated necessarily with an impairment to the slightest degree case. So what that means is if a person is charged with DUI and for whatever reason the police did not obtain, or the judge will not allow the government to use the results of a scientific sample, such as a blood sample or a breath sample, the prosecution can still proceed just on this charge alone, and that is to try to convince the jury based on other factors, like maybe how the person performed on field sobriety tests, maybe they smelled like alcohol, maybe they were slurring their speech, things of that nature, to try to prove to the jury that even without scientific evidence, you can still be convicted of a DUI. So that's slightest degree. The next step would be, as we referenced, the .08 or more statute, and that's the legal limit, so to speak. And that one would require proof of with a scientific sample, utilizing limited scientific testing procedures that are certified under the administrative code, the Arizona Administrative Code, by Arizona DPS. And they basically come down to essentially two things. One is what's called the Intoxilyzer 8000. That's a machine that you provide 2 breath samples and it provides the printout, and that machine is considered reliable enough under Arizona law to use it in court as a forensic evidence sufficient to convict somebody. The other one is to use what's called the gas chromatograph, and that's just basically a blood testing procedure that's widely considered to be very accurate for testing for blood alcohol concentration. So those are the main two. In fact, they may be the only two. And if the result is .08 or more, and the sample was taken within 2 hours of driving, you can get a DUI just on these bases alone. So driving or actual physical control with BAC within 2 hours of driving at that level is enough to be convicted, even with no evidence of impairment. The next one is essentially a step up in the BAC. So the law starts with slightest, it goes to .08, then it jumps to a DUI called extreme DUI. Extreme DUI starts at a BAC, or blood alcohol concentration, of 0.15 or more. And again, it's always within 2 hours of driving or actual physical control. 0.15 to 0.199 is what we call regular extreme DUI. Then it jumps and it says basically at 0.20 or more, there's another one called super extreme DUI. And that one it's 0.20 or more. So you could be a 0.201 or you could be a 0.35. The same statute's going to apply to you. Once you're past a 0.20, essentially the law says way too impaired to be driving. We're going to call it a super extreme DUI. And at that level, we're not going to distinguish any further beyond 0.20. There's another one in the same set of statutes, and that is any drug or its metabolite. So what that means to us is if you don't have alcohol, or you have some alcohol, but say it's the sample came back at a 0.045, so you're at 0.045. If they also test for, say, THC, the psychoactive component of marijuana, then you can be convicted of what's called a DUI drug offense based solely on the drug or its metabolite in your body. The drugs are defined in the criminal drug statutes. So basically, if it's an illegal drug that you're not allowed to use without a prescription or possess, some drugs you can't possess at all, even there is no prescription for them. Other ones are illegal to possess unless you have a prescription. They use the same definitions of what those drugs are from a biological component. And what that does is that puts a very strict law in place, and it's very strict for one particular reason, and that is the quantity of the drug does not matter. So with alcohol, you can have technically some alcohol and not commit a DUI. So a person who has one beer over the course of an hour with dinner and was to drive, their BAC is probably going to be well below 0.04. Unless they're impaired by that, they're not committing a DUI. However, if a person had just a tiny bit of any illegal drug, tiny bit of THC in their system without a prescription, and they were driving, then the DUI drug statute applies. So it doesn't have those levels of 0.08 extreme. The drug, if it's simply there, that's enough to convict you of a DUI. All right. What we talked about so far are drugs that are actually psychoactive. So it's very important to also know the metabolite of some drugs are non-psychoactive. So the reason it's new is there's a new case that came down from the Arizona Supreme Court that essentially states if the component, the metabolite from the drug does not actually affect or impair the mind, it's not psychoactive, then it's not a DUI. So a person who consumes, again, we'll go back to marijuana, who consumes THC, your body's going to break that down into the main metabolite that's going to stick around for some period of time. Is called carboxy-THC. And for a while, prosecutors got away with prosecuting for DUI people who only had carboxy-THC. The problem was carboxy-THC does not cause any psychoactive result in your brain. It doesn't impair you. So a person could consume THC and then they can have carboxy-THC still in their blood, say 2 days later. They're not impaired, and at that point they can still technically have been convicted of a DUI. However, in recent months, it might have been more than a year ago now, the law has been clarified by our courts, Court of Appeals and Supreme Court, to say no more. Carboxy-THC or any metabolite that's not psychoactive is not by itself sufficient to convict somebody of a DUI drug. You've got to have some kind of impairment. You have to have some kind of drug that would cause impairment in order to convict. All right. The other topic through all of the ones we just talked about, slightest degree, 0.08, 0.15, 2.0, and DUI drugs, is the possibility that it would be a second offense as well. So that if you see second offense, that means the government is alleging that you've had a DUI within 84 months before this one. So 84 months translates to 7 years. So basically for a period of 7 years, if there are 2 DUIs in that period of 7 years, the second one's going to be called a second offense DUI, and it's based on the dates of commission. So not the date of conviction, not the date of a jury trial, not even the date of when they charged it or not, date of commission of the offense. All right? So that applies across the board to all the ones we talked about. Something else that applies across the board to everything we've just talked about is that all of these so far, by themselves as I have described them today, have been misdemeanor charges. All right, so those have not been felony charges. As a quick side topic,